The testimony of Stormy Daniels has been a sideshow and has distracted attention away from what I consider to be the core legal issues in the New York criminal trial of Trump. As a legal matter, it does not matter whether Stormy Daniels is telling the truth about her one-night stand with Trump. The issues are whether there is sufficient proof that ties Trump to the falsification of business records, which did in fact take place, and whether the falsification was done with the intent to commit or conceal another crime. Even if Daniels lied about the sex, she was still paid $130,000 by a LLC created by Michael Cohen to keep her quiet about her allegations, and Cohen then sought to be reimbursed by Trump for $130,000 times 2, or $260,000, a sum that was grossed up to account for state and federal taxes Cohen would have to pay if the reimbursement was classified as a legal fee, as it was, paid to him, rather than simply a reimbursement of the $130,000 payment, which would have avoided the tax obligation. There would be no reason to gross up the $130,000 payment to $260,000 if it was going to be classified merely as a reimbursement of what Cohen paid to Daniels through that LLC created for that purpose. Cohen has pled guilty to a criminal campaign law violation in connection with that payment, and that may be sufficient to be the other crime when the prosecution provides the foundational proof that those transactions and others, including the alleged conspirators' involvement in the AMI hush money payment to Karen McDougal, were part of a conspiracy to influence the election through unreported and illegal campaign contributions. I suspect the prosecutor is using the conspiracy statute, section 17152 of the New York election law, which I discussed in my last video, which I will link in the more section below, to make everyone who is a member of the conspiracy responsible for each other's acts and furtherance thereof. Think of RICO as an analogy here. The conspirators would be, the alleged conspirators, I should say, are Trump, Michael Cohen, AMI, David Pecker, and Weisselberg, who was involved in the reimbursement of Cohen and the categorization of those reimbursement as a legal fee. The co-conspirators' statements made in furtherance of the conspiracy or as part of the conspiracy can be used against other co-conspirators under the evidence rules in New York and are not viewed as hearsay. The rule in New York is codified in section 8.09 of the New York Rules of Evidence, which is similar to the federal rules, which I'm familiar with.